Well, hello, everyone. In this lecture, we will be discussing the federal courts. What is the function of the federal courts? Well, we know that the legislative branch writes the law, and the executive branch is responsible for enforcing the law. The federal courts are supposed to interpret the law, and this is a little bit problematic because don't we know what the law says? Can't we just read it? And the answer is that's not really what is meant by interpret the law. The courts are responsible for determining what law applies to what circumstances. I mean, for example, if we look at copyright law, there is a portion of the copyright law that allows for the fair use of music, for example. If I were to, I have an iPhone here, which is got a lot of music on it. If I play this music and let you listen to it, is that fair use? I think most people would agree that that's fair use. I mean, that's what most people think of when they think of music. It's something that is to be played and shared between you and your friends. If I sold this iPhone to you with the music that's on it, am I violating the fair use by selling it to you, even though the original person who created the music is not getting anything from me selling this phone to you? Well, that does raise some questions, but I think most people would probably think that it's okay for me to resell music that I've legally purchased. What if I was a music creator and I liked the melody that is in one of the songs on my phone here and decided to use that in a song that I wanted to write? Is that fair use? I kind of think that most people would agree that that's not fair use. But again, I think it would come down to a question of how much of the song did I appropriate? Did I use the entire melodic line, or did I just borrow a few notes and then change the rest of it? That's really what we're talking about when we're talking about interpreting the law. Under those facts, does what I did violate the laws dealing with the protection of copyright? So what I want to do here is I want to talk about the judicial branch in general. I want to talk about some of the remedies that are available under the law. Some of the well, we'll talk about both equitable and legal remedies, what the difference is between them. We'll talk about the common law. We'll talk about criminal law and what types of crimes are in existence. We'll talk about the concept of jurisdiction. And we'll walk through the relationship of the state courts to the federal courts. And finally, well, almost finally, we will talk about, many of you know that I work in the field of death penalty litigation. And what I will talk about penultimately is the exactly what do you have to do to get from being sentenced to death to the point where you're ready for the state to complete the sentence and execute you. And then finally, we'll look at the United States Supreme Court and talk about the idea of originalism and activism in constitutional interpretation. So, all right, let's get started with the types of remedies that are available. I think I have a document here that we're going to, some notes here that I want to follow. So let's share those notes. So, all right, starting here with the top of my list here, the types of remedies that are available are either legal remedies or equitable remedies. Legal remedies generally are um, monetary damages. If you were injured in an automobile accident, for example, and if I hit you with my car and it was my fault, you sued me for the damage that your car sustained and maybe the medical bills and pain and suffering and that sort of thing. I would be obligated, or my insurance company would, if I had one, to pay you the reasonable value of the injury that I caused you by hitting your car or hitting you. The other form of remedy here is equitable remedies, and these are generally remedies that deal with behavior. A best example of that is in a divorce case, the court may enter an order uh, governing child visitation if there are children. The court may require that the parents share custody of the child, that they behave in a certain way by not engaging in uh, um, criticism of the other parent in the presence of the child. Things of that sort could all be ordered by a court under an equitable system. The idea is that this is supposed to be a way of making things as fair as possible between all of the parties, although quite often both parties don't really like what the court is ordering them to do. It's still an attempt to establish equity or equality for all the parties. Now, um, there are some terms here that we need to go over. Common law. Common law is, I've read several definitions of common law, and the odd thing about it is that the common definition of common law is unwritten law that's developed over the years by judicial opinions. And that in and of itself is a contradiction in terms because all judicial opinions are written. But what they really mean by common law is that this is law that has evolved over the centuries through the judicial branch, just defining what the various laws are. And, when we talk of common law crimes are crimes that have been in existence since the beginning of society. So murder, trespass, burglary, robbery, rape, all of these are offenses that have existed since society began. Those are all things that are common law crimes. And we call it common law, and under common law, we use the system of stare decisis, which is a Latin term for, a loose, bad translation of it would be, we already decided that. And the idea is this is under common law, the thought is that we try to maintain consistency in interpretation of the law. So if under the same facts, a previous judge had already decided that this is the outcome, then subsequent judges should use that previously decided opinion to guide them in their future applications of the law. So, if you broke into somebody's house and you had a firearm and your intent in breaking in was to steal things from inside of the house, that's a classic case of burglary, because burglary is a trespass combined with the intent to commit some kind of crime while you are trespassing. In the future, another person who is trespassed and it was clear that their intent was to steal something while inside the house, that person would also be charged and properly convicted of burglary under the concept of stare decisis. This is a consistent approach to the law. Now there's another kind of law other than common law, and that is code law. And this is there really is no interpretation in code law. There's merely application of code law, and it's different from common law because stare decisis doesn't apply. There is one state in the United States that uses code law, when sometimes referred to as a Napoleonic code, and that's Louisiana. And the reason why Louisiana uses the Napoleonic code is that we bought Louisiana from France, which was at the time, being run by who. Um, Napoleon Bonaparte, who was responsible for implementing and applying the Napoleonic Code. So that's the fundamental difference between common law and code law. There is no federal common law, so you could, I suppose, say that the federal government more or less operates under a code system, not the exact Napoleonic Code, but if the matter is not covered under the federal statutory scheme, then the law that applies would be whatever the law is in the state where you committed the crime. A good example of that is when John F. Kennedy was assassinated in Dallas, Texas. The agency that arrested Oswald, the man responsible for killing Kennedy, was the Dallas Police Department, and the agency who would have been responsible for prosecuting Oswald would have been the local prosecutor, because at the time there was no federal statute governing murder of any kind. There is now, of course. You can't even you can scarcely even criticize a public federal official without getting an invitation without being invited to explain yourself to some federal investigator. But certainly you cannot threaten a federal public employee. You will get prosecuted for doing that. Now, two different types of crimes, as we've listed as next, in my list of things we're going to cover, is malum in se, which is Latin for evil in and of itself. And generally these are similar to the common law crimes, which have been in existence since society began. All of the things that are morally wrong kinds of crimes, like trespass, murder, rape, robbery, burglary, those are all morally wrong. Now, we make the distinction between morally wrong crimes and this other type, malum prohibitum type of crimes, because they're not necessarily malum prohibitum crimes are not necessarily morally wrong. They're just things that we do because the laws in the place where we live requires us to act in a certain way. It's probably not morally wrong to try not to pay taxes or to deliberately not pay your taxes. You should pay your taxes, and you'll get prosecuted if you don't pay your taxes, but it's probably not a moral failure on your part if you don't pay your taxes. By the same token, if you drive while you're intoxicated, it's probably not morally wrong. You're not setting out to deliberately injure somebody else by getting drunk and then driving. You will likely injure somebody else if you do that, but that's not your intent. This is a malum prohibitum crime because society wants you to stop driving and while you're intoxicated. So it's a malum prohibitum kind of crime. Evil because we say so. We've decided to make it evil. That's the loose Latin translation from malum prohibitum into English. Now, in the courtroom, typically there's a judge and there's a jury, and the function of the judge is to decide what law applies to your particular case. And the function of the jury is to determine what the facts are in your particular case. Then once the jury decides what the facts are, the judge will give the jury a set of instructions telling them what the law is and how to apply it. And then the jury will reach a conclusion by applying the law as determined by the judge to the facts as determined by the jury. Now, it is possible in most cases for you to waive a jury if you want to and allow the judge to make findings of fact. But in general, most people will opt to have a jury decide what the facts are. Now let's talk about jurisdiction. Jurisdiction refers to what kinds of cases that a particular court is permitted to hear, has authorization to hear. And this is generally decided by the legislature. If we consider Florida's, the state system in Florida, there are, last time I checked, there's 67 counties in the state of Florida, and each county has a county courthouse. So at the very bottom of, we consider the layer cake model. At the very lowest level is county court, and this is a trial court. And what that means is this is the only jurisdiction that they have is to consider certain types of low-level cases at a position where they're going to be making findings of fact and applying the law only. They're not going to be any kind of review or appeals from other courts. This is the lowest level. And county court in Florida is certain kinds of cases are heard exclusively in county court. Landlord-tenant, for example, those cases are county court types of cases. Cases involving monetary disputes of a fairly small amount, those are in county court. Minor criminal offenses are also, we call them misdemeanors. Those are also heard in county court. If you lose in county court and you think that you were treated unfairly, you can appeal to the next level up. So from our layer cake description, we go from the bottom layer to the second layer. That would be circuit court in the state of Florida. And in circuit court has a combination of trial and appellate jurisdiction. In circuit court, you can, they have what we call original jurisdiction, which means that's the place where you would start your case. They have original jurisdiction over high dollar civil disputes. They have jurisdiction over family law matters, including divorce. And they have jurisdiction over more serious criminal offenses, which are called felonies. So that's the original jurisdiction of the circuit court for those kinds of cases, but they also have appellate jurisdiction to hear disputes, or rather to hear appeals from the county court. So if you were in county court and you got a decision that you disagree with and you want another judge to review it to see if the law was applied correctly, you can appeal it up to the circuit court. Now, in an appeal, this is kind of an important aspect of it. In an appeal, the appellate court will generally not reconsider what the facts of the case are. Those are determined in the trial. But they will examine the application of the law to those facts. Also on appeal, it's a general rule that you can only appeal those things which you raised in the lower court. You can't raise a new argument on appeal for something that you never asked the lower court to consider. That's just, it's not fair. So, all right, that's the circuit court, county court. Now let me hang on a second. I'm pulling up something very quickly. I want to talk about the district courts. And also something else, which about the grand juries, which I'm going to talk about in a minute. But here we have, let me share this with you. See if I can bring up the right page. Hold on a minute. There we go. All right. Now this is a map of these are the district courts of appeal that we have here in Florida. So we are we're in Tampa. So the Second District Court of Appeal would hear any appeals from the next lower level. So if we're talking about the layer cake again, we have county court at the bottom, circuit court is next. The third in the level is the district courts of appeals. And for the vast majority of cases, this is as far as you can take your case. If you lose in circuit court and you want to appeal it, you have to go to whatever district court you're in, which in our case, we're in the Hillsborough County area. You would most likely wind up in the Second District Court of Appeal. Again, their jurisdiction is strictly appellate jurisdiction. There's no trials held in the District Court of Appeal. They're only doing appellate review of things that came up from the circuit court, and on rare occasions they can hear something from the county courts. And you see that there are six currently. There are 6 district courts of appeal in Florida. Now the final layer, which is the Florida Supreme Court. It is extremely unlikely that you're going to get your case heard by the Florida Supreme Court. One of the functions of the Florida Supreme Court is what they call conflict jurisdiction. And what that means is, we were just looking at a map of the 6 district courts. Let's say that the Second District Court has issued a ruling, but the 5th District Court, on fundamentally the same facts, has issued a ruling that it conflicts with the Second District's determination. That's one of the things that the Florida Supreme Court would be responsible for ironing out. Differences of opinion between 2 district courts. The Florida Supreme Court might take jurisdiction of that and tell us which court is wrong and what is the correct way to decide those things. That's important because circuit court judges are bound by the opinions of the upper level courts. That's the way stare decisis works. If it's been decided, you have to follow what the opinion says. But if you have 2 conflicting opinions, which one are you supposed to follow? As a general rule, a circuit court will follow the ruling that's in the district court that controls directly. But the Hillsborough is in the Second District Court of Appeals, so circuit courts in Hillsborough County would probably follow what the Second District said. But the fact that there's another opinion out there from another district causes some it's conflict, and that's one of the things that the Florida Supreme Court has jurisdiction to consider and resolve. The other thing that the Florida Supreme Court has jurisdiction over is what we call writs of certiorari, which is a request to review something from a lower court, and generally that's going to be death cases. Death cases go directly to the Florida Supreme Court. They bypass the district courts of appeal. And that's because death cases are pretty serious cases. So of course the Florida Supreme Court takes those, and they're supposed. The farther up you go on the layer cake model, theoretically, the better quality the judges are, and that's generally true. I've encountered some pretty dumb circuit or county court judges. The circuit court judges are better, and the district courts they get there by people understanding the quality of their rulings and the validity of their rulings. So, all right, where was I? All right, so we've gone through the entire layer cake model at the state court level. We'll go up to the federal court in just a minute, but I want to talk about equitable writs. Let me go back to my notes here. These are the different types of equitable writs that are available to a court that will assist it in doing what we call equity. The writ of certiorari is really just, certiorari is loosely translated from the Latin, is just a writ of inquiry, and it's a term of art, really. You use a writ of certiorari to ask the Supreme Court to review your case, whether it's the Florida Supreme Court or the United States Supreme Court. That's what a writ of certiorari is for. It's the vehicle that you use for getting into the Supreme Court. A writ of prohibition is used by if it's to from a it's for an upper court to tell a lower court to stop doing something. So if, for example, 15 years ago I stole some food from the grocery store, and I've never been arrested in all this time for doing that, and the statute of limitations for the crime that I committed has passed, and suddenly the prosecutor decides it's time to prosecute Freeland for doing that. So they arrest me and put me on trial for theft. And I argue to the judge that it's too late. The statute of limitations has passed, and by law I shouldn't be prosecuted. And the judge says it doesn't matter, Freeland, we're putting you on trial. I would then go to the next level up, which I presume would be either circuit court or district court, depending upon what I've been charged with. And I would ask the upper level court to issue a writ of prohibition telling the lower court to stop prosecuting Freeland because the statute of limitations has run and you have no jurisdiction over him. So that's what a writ of prohibition would be for. The next one, a writ of mandamus, we encountered that when we talked about Marbury versus Madison. The writ of mandamus is an order from a judge directing another person, usually it's a public official, to do something that they have an obligation to do anyway, but which they refused to do. Another example, I mean, in Marbury versus Madison, it was Marbury was asking the U.S. Supreme Court to issue a writ of mandamus to James Madison, directing him to give the commission of Justice of the Peace for District of Columbia to Marbury. Unfortunately, Mr. Marbury didn't get what he wanted, but that is what he was asking for. Another example would be if I went to the clerk of court and I asked them for a copy of the deed to my house and offered to pay for it, but the clerk of court refused. I could get a writ of mandamus from a judge directing the clerk of court to do her job and give me the document that I requested. The next one, a writ of quo warranto, not too common, but it's out there, it exists, and the writ of quo warranto usually is directed at a public official, and it questions whether they have the authority to occupy the office that they are in. What right do you have to behave as a public official? If a person was elected and there was some kind of election irregularity, you would use a writ of quo warranto to question whether the election was properly held, that kind of thing. Finally, we have down here the next page, writ of habeas corpus. And we looked at writ of habeas corpus a long time ago when we looked at the Magna Carta. A writ of habeas corpus is loosely translated, it means, why have you got my body locked up? And it's used by anybody who is incarcerated, asking a judge to, some judge, any judge, to look into the conditions of my confinement. Why am I being locked up? Is there a good reason for me to be locked up, or is somebody just made a mistake? All right. So writs of habeas corpus are the bane of my existence, because doing death litigation as I do, I frequently encounter a writ of habeas corpus. And presently I'm working on a case where the defendant is on death row for 2 different murders, and he's filed a writ of habeas corpus in each one of them, and each writ is over 100 pages in length. So it's they tend to be lengthy. Let's look at federal courts next, and I'll come back to habeas corpus because I'm going to talk about that when we go through the various appeals that are available to a person who is charged with and convicted of a homicide and they are facing a death sentence. All right, so in federal courts, they only have 3 layers, whereas in the state level, there are county court, circuit court, district court, and Supreme Court. In the federal, there's only 3, and you will notice that district court and circuit court are reversed here. In state court, circuit court is the lower level, and district court is the upper level. But again, these are just names, so don't put too much significance in the fact that they've flipped it around in federal courts. It's just something you got to accept. In federal courts, district court is trial jurisdiction. And what that means is we have here in Florida, we have 3 district courts. There's a lower southern district, there's middle district, and northern district. We happen to live in the Tampa area, so we would be in the middle district. And so if I got arrested on a federal charge, I would be tried in the middle district, which we have a federal courthouse here in Tampa. If I'm convicted in federal court, I would appeal to the Circuit Court of Appeals, which in our case is the 11th U.S. Court of Appeals. And generally, that's about as far as I could go. I would not be allowed to get up to the U.S. Supreme Court because unless I'm, well, let's talk about what the jurisdiction is of the U.S. Supreme Court. The Article 3 of the United States Constitution tells us exactly what their jurisdiction is. It does say that they have primarily appellate jurisdiction only. They have cases, there are certain cases where you can go directly to the U.S. Supreme Court, although I don't know why you would want to do that. But they have original jurisdiction over cases involving where a state is a party, or cases involving public, ambassadors and things of that sort. But generally, the vast majority, 99% of what the U.S. Supreme Court does is appellate review of lower court rulings. So let's get into that. How would you get to the U.S. Supreme Court? You hear all the time people, when they're mad, they will say, I'm going to take it all the way up to the U.S. Supreme Court. But the truth of the matter is you probably can't. In the vast majority of cases, you can get up to the Circuit Court of Appeals, but then you're probably done. The U.S. Supreme Court considers, I've heard different numbers and it varies from year to year, but anywhere between 7,000 and 10,000 requests for review every year. So it's extremely unlikely that you, out of at least 7,000 different applicants, that the U.S. Supreme Court is going to consider your case. They only take between 80 and 100 a year. So just on numbers alone, it's unlikely that the court is going to take your case, because even if they had jurisdiction, they might not take it. They most likely won't. But the other thing is that the jurisdiction of the Supreme Court is to, again, like in the Florida Supreme Court, they look at conflicts among the various circuit courts of appeal, and they sit to resolve conflicts among the various circuits, if there is a conflict. The other thing that the U.S. Supreme Court does is they review death cases. They're still quite a busy court, but they pick and choose what kinds of cases they want to take. They have the authority to consider any kind of case that is requests a writ of certiorari. They are the U.S. Supreme Court after all. So let's look at the appeals available in a death case, and then we'll come back to the U.S. Supreme Court, and we will talk about the various justices on the Supreme Court and the significance of being a liberal or conservative justice, and the nature of original interpretation of the Constitution as opposed to an activist interpretation of the Constitution. So first of all, in a death case, the majority of death cases originate in the state level. They do have the death penalty available on the federal level, but we're not going to talk about that because it's fundamentally the same if you started out in the state level as opposed to the federal level. All of these things remain the same. So on the very first appeal that you get in a death case, you've already been to trial, and in all death cases, they have 2 parts to a death case. There's the guilt phase where they decide whether you did it, and then there's the penalty phase where they decide what kind of punishment you ought to get. And it's kind of interesting to look at this from a historical perspective, because it didn't used to always be that way. Back in the day, they had, here's an example of this case, which is United States versus Shipp, which was decided in 1909 by the U.S. Supreme Court. In this case, the defendant he was a black man who was found guilty of raping a white woman. And in those days, if you were found guilty of that kind of an offense, the only punishment was death. And so in this case, what happened was the defendant felt that maybe his trial wasn't fair because in the process of trying him, the state attorney regularly excluded from the grand jury anybody who was black, and also excluded from the trial jury anybody who was black. And so he felt that perhaps that was maybe there was something uh, that wrong about those kinds of exclusions. And the U.S. Supreme Court said, originally they said, well, we're not going to immediately grant you relief, but you do have the authority. We want you to file a writ, an appeal, and let's see if we can work this out as to find out what happened and whether you're entitled to relief. Well, before he had an opportunity to file his appeal, a lynch mob entered and removed him from the jail and executed him, by lynching him. And in this case, the U.S. Supreme Court got quite upset with the local sheriff who had failed to protect the defendant from the lynch mob, and ultimately ordered the sheriff and various other people to serve time in prison. Well, that's not really the reason why I brought up U.S. v. Shipp, but to illustrate that back in the day, if you were found guilty of rape, for example, in many states, the only punishment was death. So let's see, is this the case? Yeah, in Furman, in this case, Furman versus Georgia, this was decided in 1972. The U.S. Supreme Court found that the death penalty was unconstitutional because of the fact that what I just stated. In some states, many states, in fact, for certain crimes, once you were found guilty, the punishment was death. So if you had the misfortune of getting a racist jury who were just angered at the facts of the case, they might find you guilty, and the only option was for the court to execute you. And that kind of thing just wasn't reviewable by the upper courts. All they could do is say, well, were you found guilty? Okay, well, if you were found guilty, then you're going to die. And that doesn't take into account the possibility that there may have been something about the sentence that maybe you don't deserve the sentence. So in Furman, they struck the death sentence as unconstitutional for those reasons. They didn't like the possibility that maybe there were other factors at play other than your guilt or innocence in deciding whether you should be sentenced to prison or to death. The consequence of this, Furman versus Georgia, was, as I said, to invalidate the death penalty throughout the United States. And it wasn't until 4 years later, in the next case, Gregg versus Georgia, and let me bring that up so we can look at it, that the states came up with a different system, the system that we now currently use, which is a bifurcated system. What happens in the current scheme is we allow the jury to decide the facts, whether you are guilty or not guilty of the homicide. And then after they've decided that, we go through a second phase where additional evidence is presented to the jury, where the jury can decide whether the various aggravating factors exist. Aggravating factors would mean whether you planned the homicide out in advance, whether the way that you killed killed the victim was particularly cruel, whether you killed the victim to eliminate a witness, whether you killed the victim because the victim was a police officer. There's a whole list of possible aggravating factors that we have that a jury could find. And if the jury finds any of those aggravating factors to apply, then they could sentence you to death. Uh, on the other side, the defense may present any mitigating factors that they have. Like I've often said that in summary, we can't execute you if you are too young, too dumb, or too crazy. So a recent argument has been that what if a person has a mental age of, I mean, the general rule is we cannot execute you if you committed the crime before you were 18. So some people are floating the argument, hoping the U.S. Supreme Court will accept it. That well, what if a person has a mental age of being under the age of 18? Can we still execute them? So far, the Supreme Court has not ruled on that. They've rejected every attempt to get them to rule on that, so far as I know. But you know, those things are constantly coming up. Are you too crazy to be executed? Do you have an IQ that is too low to be executed? Um, all of those things are factors that can be argued by the defense during the penalty phase of a death case. You can bring in an expert who says that, yeah, he's too crazy. He really doesn't understand what he's doing. Yeah, he may have committed the crime, but he was in a fugue state or something of that sort. They might argue, or they could argue that they've given you an IQ test and your IQ is too low. You're too dumb to be executed. Um, that system of bifurcating the trial was approved in this case, Gregg versus Georgia, which was decided in 1976. So ever since 1976, those cases, those states that use the death penalty have used this two-stage approach to imposing death. It allows the courts to be able to review not only the guilt aspects, whether you did it or not, but also whether you deserve death. Is there some reason that maybe because of maybe you had a terrible childhood and there's mitigating factors dealing with that? You know, you're abandoned by your parents or beaten by one of your parents or abused or neglected or any of those things. Can be considered by a jury and also by the reviewing court in deciding whether death is an appropriate sentence. So, all right, going back to my list. There's my list. So on direct appeal, uh, you could ask the court to review anything that you raised at the trial court level. And this is called plenary because that's an extension of the Latin word for full. It's a full appeal. Although we generally call it a direct appeal, it's a full appeal of anything that was raised in the trial court. So if you win your direct appeal, you probably will get a new trial, most likely. If you lose your direct appeal, your plenary appeal, then we move on to the next set of appeals that are available. And these in Florida are tried simultaneously. You have an opportunity to challenge the actions of your trial lawyer. Maybe your trial lawyer missed an argument that should have been raised. And you can also challenge your appellate lawyer from your direct appeal. Maybe there's an argument that your lawyer that you had on direct appeal missed that should have been raised. And in both of those situations, you would have to prove that the argument that was missed, or that either the trial lawyer or the appellate lawyer failed to raise, would have resulted in a different outcome. So, all right, those are all true, and those are all available, and they are generally followed in almost every case. And following all of these rulings, you can ask for a writ of certiorari to the U.S. Supreme Court. But again, at this level, it's unlikely that they're going to take it up unless there's a clear constitutional violation. So this direct appeal generally takes about 2 years to complete. Depending upon the circumstances, number 2 and number 3 can take another 2 to 5 years to complete. It really depends on whether there was a hearing held, and there generally is a hearing held on the question of whether your trial lawyer was bad. They like the courts like there to be a hearing on this so that they can really flesh out what the lawyer's strategy was and why the lawyer did what they did in the direct appeal. All right. So once all this is done, it could be 8 to 10 years before we're done with all this. Then the next step is to go into federal court and ask the federal court to review all of these things to see, does any of this, what happened here, violate the U.S. Constitution? That's really the limit of what we're looking at. We're not looking at, did you commit the crime? We're really looking at constitutional violations by the time we get up to federal court. So you file what's called a petition for writ of habeas corpus in the federal court, starting in the lowest of the district, the federal courts, which is the district court. The district court may take years to get through the habeas petition and deciding it either in favor, in which case directing the state court to do something different, give you another trial, another hearing, or they can deny it. And if they deny it, then there's generally appeal to the circuit court. So we're in district federal court, or if we're living in Tampa and the offense occurred in the Tampa area, we're in the middle district. Then from the middle district, you would appeal up to the 11th Circuit Court of Appeal. And then failing that, if your appeal is denied, you can ask for a writ of certiorari to the U.S. Supreme Court. And again, that's a matter for the U.S. Supreme Court to decide as whether they are going to take it or not. After all this is done, you are deemed what's referred to as death eligible, which means that all of your appeals have been exhausted, and now we would just wait for the governor to issue a warrant directing that you be executed. And currently we have several hundred people on death row in Florida, and the determination of which of those is going to be next would be up to the executive branch to decide. When the executive branch does decide that any individual specifically is going to be executed, then all of this review of all these things happens all over again at the last minute, all over. All these arguments are reviewed just to make sure that everything was covered. And ultimately leading up to the U.S. Supreme Court, which in most cases, the U.S. Supreme Court will deny certiorari on in a death case when a warrant has been issued, but there have been some remarkable occasions when the writ has been granted and the Supreme Court has granted a stay of execution. But I'm not going to get into that. This is more about the nuts and bolts rather than the specifics of when the court might do something like that. Now let's talk about the U.S. Supreme Court. To get into the U.S. Supreme Court, the numbers are really against you. As I said earlier, as many as 10,000 cases per year, and by cases I mean 10,000 writs of certiorari are considered each year, and the court rejects the vast majority of those. So you have a less than 1% chance of getting in, because 80 to 100 cases are accepted each year. The way that you would get in is if 4 of the 9 justices agree to consider your writ of certiorari. And that just means that this is a preliminary thing. You have the opportunity to write a brief outlining your best arguments to the Supreme Court. And then they will consider those arguments, and they might set it for oral argument. They might. Or if they find that your argument really lacks merit, they could just reject it without oral argument. The court has generally 2 different philosophies of interpreting the Constitution. The one of them that is favored by conservative justices is the originalist doctrine. Those that are that which is favored by the liberal justices is more of an activist doctrine. And what this means is this. In an originalism approach, we look to what did the founders intend when they drafted the Constitution along with its various amendments. And the benefit of this is that we get it follows the rule of stare decisis. It's a backward-looking thing, stare decisis is. We want consistency in the outcome of issues, and originalism is a remember, conservatism means we're trying to conserve the past. We're not trying to create a new future, but we're conserving what has been. So we look back to what did the founders intend when they drafted this, and try to interpret it in terms of that. What is the flaw in originalist thinking, originalist interpretation of the Constitution? Well, if we go back to what was going on at the time the founders were drafting the Constitution, who was involved in creating the law at that time? White men. So women were not involved. Minority groups were not involved. So the only kind of interpretation we're going to get is the kind of interpretation that was favored by the group that was in power at the time the Constitution was drafted. So it's got some limits in those terms, but that's the way conservative justices tend to view it. Not with the limits that I'm talking about, but we want to look back to what was the original intent. An activist judge, an activist court, tends to move forward with things, and a good example of activism would be the decision of Roe versus Wade. In Roe, the court looked to the right that the recently discovered right to privacy, which had been we talked about this when we talked about the Fourth Amendment, if you recall. It applied the newly discovered right to privacy to a woman's right to control her body, and they did this by saying that if a fetus is incapable of surviving outside of a woman's body, then the woman can have whatever operation she wants on her own body. And that's basically the underpinnings of Roe. Recently, within the last few years, the U.S. Supreme Court revisited Roe, and using an originalist approach rather than the activist approach, they undid the effects of Roe, so that now, instead of having a national ruling that permits abortion, now it is left up to the individual states to decide. So, there's many examples of originalism versus activism. Another activist court decision was Brown versus Board of Education, which determined that separate but equal is inherently unequal. That was certainly, there's no arguing that was a good decision that needed to be done. But again, that was an activist court that did that. So, some activist decisions are good decisions. If we look at Roe, we've looked at the entire Constitution in this case, in this class, and I have to say that whatever my personal opinions about abortion might be, the Constitution does not say anything about a right to an abortion, and the U.S. Supreme Court saying that such a right exists really seems to me that they had an outcome in mind, and they were looking for a way to reach that outcome. So, all right, that's the two approaches to interpreting the Constitution. Let's look at the justices, and we will think back to the Marbury versus Madison case when we look at this, because it is a truism generally that a Democratic president is going to be appointing liberal justices, and a Republican president will be appointing conservative justices. And again, the conservatives are going to favor originalism. The liberals are going to favor activism generally. This has become more and more true in recent years. There have been times in the past when political ideology did not factor in so strongly in the opinions of the U.S. Supreme Court, but within the last 25 to 30 years, it's become more and more of a thing. So if we look, let's see, I have the justices. Let's see if I can find them. Let me see if I can find my images of the justices here. So, yeah, all right. So according to my list, so Sonia Sotomayor, she is a liberal justice appointed by Barack Obama. Elena Kagan, over here, she was appointed by Barack Obama. She is considered liberal. Ketanji Jackson, appointed by Mr. Biden, is considered a liberal justice. All of these other ones, however, were appointed by Republican judges and so, Republican presidents, sorry, and so they tended to select judges who were conservative in their opinions. That's how we know whether a judge is conservative or not, as we look to their various opinions. And the majority on the Supreme Court is now conservative, largely because we have, well, let's see, Samuel Alito was appointed by Mr. Bush, the first Bush, not George W. Bush. John Roberts was appointed by George W. Bush, also conservative. Amy Coney Barrett is a Trump appointee. Clarence Thomas, the only African American on the bench, was appointed by the first Bush president. Mr. Gorsuch and Brett Kavanaugh, both appointed by Trump, so they are deemed conservative. So we have a very strong conservative Supreme Court at present. That is the extent of what I intend to talk to you about tonight and or today. And it's been a pleasure walking you through this federal government of ours. And thank you for your time and your attention.